Welcome back to the video lecture on ASEAN step practice in the domestic implementation of international law. This time again, we are going to touch upon the issues of the environment. This subsection highlights the legal recognition and implementation application of the environmental rights within ASEAN, the national legal systems. The thesis or the hypothesis advanced here is that Asia's cultural heritage has influenced and ultimately found their expression in modern ASEAN environmental law. As one of the academics observed, that despite the inadequacy of the environmental legal frameworks and the lack of the government implementation in some countries, particularly in South Asia and Southeast Asia, the court have nevertheless been able to achieve the significant environmental customs by using national constitutional provisions that focus on the basic human rights, especially the right to life. It is noticed that the South and Southwest Asia lay claim to some of the world's most innovative environmental rights jurisdictions and jurisprudence, while North and Central Asia possess the regions the greatest concentration of the Constitution to featuring environmental rights. Details on environmental-related rights within ASEAN national legal systems are drawn from the two relevant data sets. Here, there are the first, the UN Human Rights Council report highlighting good practices in relation to the right to a healthy environment, and second, national entries in the Encyclopedia Public International in Asia will be mined for evidence. Thematically, these examples of the environmental rights within ASEAN legal systems are organized into three categories to discern if an identifiable ASEAN approach to implementation of international environmental law exists within domestic legal systems. Specifically, this contribution will highlight the growing significance of the role of domestic institutions, especially municipal courts, in developing important environmental law concepts, principles, and standards, which in turn both inform and animate international courts and tribunals accordingly. The three thematic categories are: the first, substance environmental rights included in either national constitutions and/or the primary registration and/or jurisprudence of adjudication bodies. And second, procedural environmental rights included in the some sources. And third, national legal systems reforms and all institutional restructuring for environmental protection. An example of this third category is the introduction of specific courts or the repurposing or retooling of domestic courts for environmental protection. While the differences between substance or the procedural environmental rights is not always clear, both legally or doctrinally, a loose distinction can be made between substance rights to a healthy environment and procedural environmental rights, such as the right to access to information, consultation and participation, for example, through the environmental impact assessment, as well as access to justice on environmental matters. When considering substantive environmental rights within ASEAN municipal legal systems, a conceptual distinction can be drawn between the legal provisions for human rights to healthy environments on the one hand, and the recognition of the legal personality for natural environmental objects such as livers, coupled with the provision of rights for representative of these natural entities, as well as for endangered the wildlife species of flora and fauna. It is important to note that there is no ASEAN continent-wide instrument that incorporates this right to a healthy environment, nor is there a pan-ASEAN court or tribunal that can perform this role. The recent UN Human Rights Council resolution on human rights to healthy environment also received attentions but abstentions from the Russia, India, China, and also Japan. Moreover, the inclusion of the right to a healthy environment within ASEAN constitutions and all primary legislation is very seen on the ground, within less than the 20 Asian states having done so, even though the constitutions of the Philippines and Vietnam to protect this right. There are hints of a recaptured the environmental consciousness within the legal imagination of ASEAN national systems, springing from the traditional and cultural connections with the natural environment. Recent accounts of ASEAN environment history provide evidence for such a link between traditional ASEAN culture and modern-day legal concept for environmental protection. For example, in India, the High Courts in the Uttarakhand ruled in March 2017 in the cases involving the Ganges or Yamuna and Glacier that the Ganges and Yamuna rivers and Gangotri, the states, and also Yamani the glacier, as well as the natural objects in the state of the Uttarakhand in India, had a legal personality and enjoyed legal rights. This is at least in part due to the court's assessments of these rivers as sacred and revered. Although these potentially groundbreaking decisions have not been stayed by the Indian Supreme Court, depending on judgment on these matters, their implications continue to ripple across the legal spectrum. Mongolia, for example, they provide historical ancestors for the natural environmental protection through the Ikjakak, which is a great the Yasaro code introduced during the Mongol Empire. This tradition of ecological protection continued unbroken for centuries, and with the declaration of Bog Mountain and the Khan-Kenti Range as sacred places, Mongolia was the first nation to ever create a natural reserve in history. The present Mongolian constitution provides for the right to a healthy and safe environment and to be protected against the environmental pollution and ecological imbalance. The UN Rapporteur on Human Rights and the Environment has also noted that a growing number of constitutions incorporate duties relating to the protection of wildlife and nature, including those of Bhutan, where the constitution requires 60% of land area to be maintained under the forest cover for all time. 7 West Central Asian states are among 45 parties to 1998, whose Convention on Access to Information, Public Participation in Decision-Making, and Access to Justice in Environmental Matters. And 11 states from West Asia and Arabian Peninsula are among 16 state parties to Arab Charter on Human Rights, and the 10th state has adopted the non-binding the Declaration on Human Rights of the Association of South Asian Nations, the ASEAN. Moreover, the UN Rapporteur has highlighted at least 20 states worldwide, including the West Central ASEAN states of the Azerbaijan, as having constitutions which guarantee the right to access to environmental information. In 2014, China revised its 1989 environmental protection law and strengthening the speculation regarding inter alia the public interest litigation, providing clarification on what entity may qualify as a plaintiff to litigate against polluting activities. The next subsection highlights the potential for these procedural reforms to enhance the prospect for climate change-related litigation in China. The Indian judiciary is among the most active in public interest litigation. As one of the academics notes, the engagement of the Indian judiciary with the international environmental law is very visible in the context of the importing of key principles of international environmental law to domestic legal system. Nearly all these exercises are made possible through the process wherein judges of higher judiciary in India got an opportunity to be creative by diluting certain procedural requirements for the purpose of ensuring substantive justice. In Sri Lanka, they note that some NGOs have gained recognition for playing a leadership role in ensuring the conservation of the environment and enabling unimpeded exercise of the related rights of the citizens, especially through litigation. Indeed, the positive impact of the judicial review and the active participation of both government and non-government institutions to resolve environmental disputes have turned a new page in environmental law in Sri Lanka. In Thailand, in other example, the Section 70 of the 2017 Constitution confirmed certain substantive and procedural environmental rights inter alia, the substantive right to conserve and restore custom, the traditional knowledge, art, and culture, right to management, maintenance, preservation, and exploitation of natural resources and the environment, right to access the community resources, and the right to access justice, and right to access environmental information, and right to participate in environmental decision-making as procedural the environmental rights. A slight oddity is Singapore's lack of environmental impact assessment or even public consultation type law. Instead, such consultations have been conducted on an ad hoc basis to seek the views of the public, including specialist environmental communities. In this regard, Taiwan represents a useful test case for the premise of this research or this lecture, namely the role of municipal law as an expression of domestic implementation of international law. Taiwan is implementing environmental treaty, the provisions voluntarily, even though Taiwan is not formally a party to these treaties. For example, while the Taiwanese Environmental Impact Assessment Act initially followed the American practice and later revisions landed the 1998 Aarhus Convention, despite the fact that Taiwan is not a party to this convention. The UN report observed that globally there are more than 1,000 specialized environmental courts and tribunals at the national and subnational levels. The advantages of these, the judicial and quasi-judicial bodies include enhanced legal and scientific expertise, and streamlined processes and flexibility, the use of alternative dispute resolution, comprehensive jurisdiction, open rules about the standing, for example, eligibility to file cases, and effective remedies and enforcement powers, and unique case management tools. Examples highlighted by the UN report include the National Green Tribunal in India. Moreover, in most states where the right to safe, clean, healthy, and sustainable environment is recognized in the Constitution, individuals and non-government organizations have a standing to bring lawsuits based on the violation of these rights or of the environmental laws. The Philippines, for example, has made great strides on all three related fronts. The first, the 1987 Constitution established the substantive environmental right. And second, in 2A, the Supreme Court established especially the Design Environmental Code. And third, in 2010, the court issued the rule of procedure for environmental cases. The innovative legal remedies has also been introduced. Elsewhere in South Asia, the law reform on procedural environmental rights has extended to judicial training on environmental expertise. For example, under Indonesian law, let's say about regarding environmental protection and management, every person has a right to access to information, to participate in environmental decisions, to effective remedies if they are harmed by the environmental degradation. The Supreme Court has adopted policies that require all environmental cases to be handled by a judge with environmental certification, for example, obtained through the specialized training. Overall, it is possible to discern attempts by ASEAN national legal systems to reference traditional ASEAN notion of a human nature harmony when introducing legal provisions, remedies, and reforms for environmental protection. Thank you very much for your very kind attention.